Thank you and welcome to today's session. I'm Melissa. I am one of the coordinators in the Rady Faculty of Health Sciences Family Center. At the center, we're here to support learners, staff, and faculty as they navigate the challenges of caregiving while studying and working in the Rady faculty. And we hope to provide a more family-friendly campus. So today's session is called The Basics of Estate Planning, Wills, Powers of Attorney, and Healthcare Directives, and it will be facilitated by Andrew Torbiak. Andrew is an associate lawyer at the Traditional Law LLP Estates and Trusts in Winnipeg. He maintains a broad practice in estates law, an emphasis on estate planning. And prior to being called to the bar, the Manitoba Bar in 2016, Andrew attended the Asper School of Business, class of 2012, and the Robson Hall Faculty of Law, where he earned his Juris Doctorate degree in 2015. Since graduating, Andrew has become a sessional instructor of legal negotiations at Robson Hall, and he coaches third-year law students at the Canadian National Negotiation Competition. Before we start with this session, I would like to do the land acknowledgement. So the University of Manitoba campuses are located on the original lands of the Anishinaabe, Cree, Oji-Cree, Dakota, and Dene peoples, and on the homeland of the Métis Nation. We respect the treaties that were made on these territories. We acknowledge the harms and mistakes of the past, and we dedicate ourselves to move forward in partnership with Indigenous communities in a spirit of reconciliation and collaboration. And just a few housekeeping rules. If we could keep our mics muted during the presentation, and feel free to write any questions that you may have in the chat box, and Andrew will get to them at the end of the presentation if time permits. And I also want to let everybody know that this session is being recorded. And so now, without further ado, please join me in welcoming Andrew.
Hi, everybody. Melissa, thank you very much for that warm introduction. Welcome, everybody, on this gorgeous, crisp autumn day we're enjoying. Again, my name is Andrew Torbiak. I'm a lawyer practicing in the law firm of Traditional Law LLP, as you can see there, specializing very much in estate planning. So I'm very pleased to have the opportunity to speak to you all about this. As Melissa mentioned, so I'm hoping that I'll be answering your questions by virtue of the information that I'm covering. The topic for today is essentially just the basics, starting from the ground up. What's a will? Why do I need one? What's a power of attorney? Why do I need one? What are some of the considerations I might have while making those documents? And why do I need to pay a lawyer to do that too? Fair enough. And then just before I set off, I will certainly be taking questions either through the chat or directly at the end of the presentation. I know the presentation is scheduled for an hour. I have time. So if we're going over or if people need to drop off, no trouble at all, but I will do my best to entertain all questions as they arise. Okay, so the three main documents that make up what we consider an estate plan would be a will, a power of attorney, and a healthcare directive. So whenever you hear the phrase estate plan, I find that to be kind of a buzzword that sounds very simple and we hear all the time, but we don't actually know what it means. This is what it means in very basic form. So your will is a legal document that appoints somebody to be in charge of your estate. That's the executor. And then also lays out how you would like your estate to be distributed. So who your beneficiaries are. As you may already know, a will is not effective, of course, until you pass away. Then we have a power of attorney and a healthcare directive. Those documents are separate from wills. That's a very common misunderstanding that when people think that when they've appointed an executor, they've also appointed a power of attorney, for instance, and that's not the case. They're separate things, and they control separate decisions. So power of attorney is used to appoint a decision maker who can make decisions governing your property, your money, and just do things for you, pay your taxes, sell your house if necessary, handle your personal affairs, Healthcare directive is supposed to be a separate document and a separate, let's say, portfolio of decisions, mostly concerning your medicine and your personal health. Turning to the will. The first question I always like to tackle, why do I need one of these? I'm married or I have children. There's no problems. Why do I really need to put one of these together? So as I already started alluding to before, well, you get to handpick in your will the person who is in charge of the handling of your estate. That's your executor. And you can also write into your will different layers. So again, let's just say you have spouse and 2 kids. You can name your spouse first. That makes perfect sense. But in your will, you can also name an alternate for if your spouse passes away. So it's your oldest child, and then your next oldest child, and then, you know, whomever. Also in your will, you can lay out how you want to distribute your estate. It may be very straightforward. It may just be first to spouse, then to children, and that's fine. However, if you would like to include any layers, that's what a will is good for. So if your spouse has passed away, heaven forbid, what happens if your child has passed away? Well, we can dictate that their share go on to their children, or we can dictate that their share go on to their spouse or charity or some other kind of arrangement. So I'll get more into the inner workings of that, but that's essentially just what you need a will for. Touching very briefly, why then do I need a lawyer? That's fair enough. And I'll just say at this point, you can take my answer with a grain of salt because this is what I do. I want this to be a learning exercise for you, not a sales pitch for me. So get a second opinion. You're perhaps mostly working around the medical field, so hopefully that's a phrase that's commonly used. Anyway, technically speaking, you can write your own will. It's called a holographic will. It sounds much cooler than it is. That's just the legal phrase for writing it out yourself in your own hand, meaning in handwriting. There's lots of problems with those. They're hard to decipher. It's hard to determine exactly what it is the person intended. The person who wrote the holographic will very likely didn't include certain language that should be included to establish, you know, certain powers in your executor or properly deal with the estate. It's far more likely that if you write your own will, there will be unforeseen legal consequences resulting. So for instance, I'm appearing in court, I'm phoning into court in a couple weeks to deal with a handwritten will that was a kit that came out of a funeral home. There's nothing really technically wrong with it, but we technically do have to ask a judge's permission to pass the will. It won't pass probate simply by itself. Try as I might to do things quickly and efficiently, it's still going to cost a lot of money. So writing your own will, I guess I would describe as being penny wise but pound foolish. They say the person who acts as their own lawyer as a fool for a client, and perhaps more pertinent to this crowd, don't do your own surgery. And then also what happens if I don't have a will? So a lot of people don't know that in Manitoba, we have a statute. It's called the Intestate Succession Act. It's essentially a statutory will. So if you don't write one out yourself, the government has already established one for you. It's extremely cookie cutter. It's extremely paint with a broad brush, we'll say. So it already directs who could be in charge of your estate, in what order. So that might be spouse, and then it might be all of your children with equal entitlement. Or it might be a case I worked on, 13 cousins, equal entitlement. They all had to agree who was going to act. You can imagine what that would have been like. The act also lays out how your estate is supposed or must be distributed. So it says first, everything to your spouse. If not spouse, everything divided evenly between children. Maybe that works for you, and that's fine. However, it also says if your spouse is not the parent of your children, your spouse gets 3/4 of your estate and your children split the last quarter. So as we're seeing more commonly, the phrase is blended families. So second, marriages or people are passing away with partners who are not the parents of their children. Fine, nothing against that. If that distribution scheme will cause issues in your family, that's where a will would come in. So I guess I'll just suffice it to say this cookie cutter, it doesn't work for everybody's situation. It can create a lot of legal inconvenience, or downright the wrong people are inheriting from you. Another couple issues, if you haven't got a will that appoints an executor, people can apply to be in charge of your estate, but they need the court's permission for that. So they apply to the court and the court says yes or no, and normally it's granted. However, there is one rule which says your administrator, which is what the role is called if you don't have an executor, it's your administrator, must reside in Manitoba. For a lot of people, that in itself could be a problem if the people they choose to be their executor or their alternate executor don't live in the province. All just very, very basic reasons you might want to put together a will. Good. So we've already briefly chatted about the specific elements in a will. Already mentioned the executor. That's sort of like your project manager for your estate. So it's their job to collect the assets of your estate, to pay the debts and expenses and taxes of your estate, and then to follow the distribution scheme that you've laid out in your will. And now we turn to the distribution scheme. So you'll see a few points here. Get my laser pointer. In your will, you can specify gifts to people. So, your watch, it's your grandfather's watch or your grandmother's watch, china sets, whatever, some kind of keepsake or tools or rifles or whatever it is. You can put that by name in your will. You can also specify monetary gifts. So a certain amount of money to each grandchild or a donation to a charity. No matter how large or how small your estate is, that specific amount of money will never change, and it automatically must be made because you put it in your will. And then you get to distributing specific assets. So we're not talking about silver spoons or cash amounts anymore. We might be talking about pieces of property, corporate shares, or accounts or investments. And then finally, we come to a phrase here, residue. So residue is, as it sounds like, what's left over after all of these specific things have been distributed. So residue is usually the most common way that people distribute their estate or their wealth. So residue means taxes have been paid, lawyers have been paid, accountants, funeral, and all these gifts have been made. Now we have this remaining pile of whether it's money or value in a house or whatever it is. And the will dictate how the residue gets divided. Usually that's in a percentage scheme. So common example, I give my residue all to my spouse, which means 100%. If my spouse has passed away, now we're writing in the layer here, I divide my residue evenly into as many children as there are surviving. Children is a specific legal phrase. It means biological or adopted, not stepchildren. You can include those people, but anyway. Or you could say, I don't have children. I have nieces and nephews and they're okay. And I also have some favorite charities. So I'd like to divide 50% of my residue between my nieces and nephews and 50% between my favorite charities. I like to say it's your pie. You get to distribute it and cut it up however you want. Some other points that you can use your will to speak to or control. So you can create trusts with your will. So a trust is like a legal holding place. And it's used to serve a specific purpose. I'll get into it a little bit further coming up. You can also appoint guardians for your children. So if you and your children's other parent have both passed away, it's essentially an endorsement by you of who should raise your children after you've passed away. It's not binding, technically speaking. So you can't say Michael Jordan is going to be the guardian of your children. You can say, you know, their grandparents or their aunt and uncle. It's not binding because if the aunt and uncle have moved far away from the children since you wrote your will, this might disrupt the status quo of the child. So it's not binding because it might have been a good idea when you wrote your will, but circumstances have changed such that we need to relook at the situation. However, it is highly, highly influential when you put something like that in your will. And then, of course, you can include directions for what should happen to your remains and what your wishes might be for funeral. I just wrote a will that included a fireworks display, so that was fun. The term of estate, I find, is also a bit of a misnomer. It's a word that gets thrown around, but isn't very well understood or we'll say, you know, defined or explained all the time. So I'm going to elucidate that for you right away as well. There are three main ways to pass property when you pass away. The first is through joint ownership. Second is through beneficiary designations. And then the third is through your estate, which is interesting. I think most people, when they say estate, they just mean all of it. Whatever there is when I pass away, whether I own my house with my husband or wife, whether I have a life insurance policy that goes directly to my child, you know, whatever it is. A lot of people refer to all of that as estate, but that's not actually the case. So what's an estate? Here's my amazing schematics, and stay tuned, they're going to get better. Your estate for legal purposes is only property or assets that you owned solely when you passed away and that do not have beneficiary designations. So actually, if you and your spouse own most of your assets together, or if you don't own it together, you've attached your spouse to that asset by way of a beneficiary designation, meaning they get it when I pass away. Those items, you can see here, are left out of your estate. They just go directly to the person who's already on title or who is named as a beneficiary or is designated on, say, a life insurance policy or tax-free savings account. Joint property, the most common example I already gave is say, a marital home owned by two spouses. Each owner, by the way, I said my schematics are going to get better. Each owner is considered a full owner. They both share 100%. So it's not 50-50. So for the most part, when the owner of a house passes away, the entire title to that house goes to the surviving title holder. That's the most common way to do it. There is an alternative, but I'm just going to leave that out for today's purposes. Those joint assets are accessible to creditors. So if owner one has a creditor and their name is on the house, even if owner two is also on that house, creditor can still go after that asset. So your estate plan can also consider things like that. And then, of course, joint property is well, separable. If there's ever a divorce or separation of a marriage, and your estate planner can consider things like that as well. Next, we come to beneficiary designations. This is, you know, the most state-of-the-art that I have. So probably at this point, you're thinking, well, what's the best thing? What do I do? What actions should I take? For the most part, it's perfectly advisable to let your assets pass to your spouse automatically after you die by either joint ownership or beneficiary designation. There's good reason for that. There's certain benefits that come with passing assets that way. So for one thing, if your house goes automatically to your spouse when you pass away, there's no land transfer tax. You file one form at land titles, it's $109, it's no big deal. No estate, no nothing. Same goes with life insurance. I don't want my $500,000 life insurance policy to hit my estate and take a while to come out and perhaps be chewed up by some fees, things like that. I just want it to go straight to my spouse. Tax-free savings account, well, by its very nature is tax-free. Why shouldn't that just go straight to my spouse if they're my main beneficiary? RRSPs, those can be rolled over tax-free to your husband or wife without there being a deemed distribution, meaning without them being taxed as if you had taken them out as income. All of that makes perfect sense. And for the most part, that's what we recommend unless there's something very special affecting your situation. However, when it comes to children or somebody who isn't your spouse, children being the most common example, issues arise when you transfer wealth by beneficiary designation. So, okay, we're here. So one issue is, a lot of people don't know, RRSPs, unless they go to your husband or wife, are fully taxable when you die. That's because while they're building, they've been tax deferred. So when you pass away, the tax rules say all of the money in your RRSP is deemed income to you, and therefore it's taxable under your estate. What a lot of people do is they attach their children to the RRSP, and all of that money flows to the children. The taxes still exist here. Maybe I'm using the wrong tool. So what happens is the children have the cash in hand, but the estate has to foot the bill. The estate might actually get to be bankrupt if there's not enough cash to pay the taxes. That can be a big problem for your executor. You'd actually have CRA coming after your executor. You'd actually have CRA coming after your kids to recover that money. So that's one issue. That's one reason we usually recommend, just put all of those assets through to your estate instead. Another example is, what if your child passes away out of order? So we always like to assume, of course, that we pass away generation by generation, and heaven forbid that isn't what happens, but situations arise, and we'll pick on child one here. Child one has passed away. Maybe all of a sudden, the effect of your beneficiary designation is everything goes to child two. But what if child one actually had 3 of their own kids? And now by virtue of this arrangement here, you've inadvertently left out your grandchildren. So, not the best situation for them. Thanks for bearing with me. Instead, the alternative we normally suggest is you pass the assets through to your estate. This way, you are ensuring that the assets will be governed by your will. So in your will, you can make sure that all grandchildren are also written in, or you've written in alternative beneficiaries if something happens to child one again. And your will might very well say, well, all of it is just going to go to child two in that case because we don't have any children up here. Fine. But then you also avoid any issues of, say, unpaid tax or bankrupt estate that has more debt than it has assets. All of these assets can be used to finance your estate, essentially, and settle things out properly and avoid any kind of trouble. That's very basic estate planning. I won't sort of go further and make this too convoluted, but that's just some background on considerations you might make for how your wealth passes on, whether it's by joint title, beneficiary designation, or through your estate. A major consideration that you might make while approaching your estate plan is how to plan for your children if they're young. By young, I mean, let's say 18 or less. So I've touched on guardianship already. That's something you include in your will. A little trick you can employ with your power of attorney is including a power that allows your attorney, not a lawyer, just the person you've named in the power of attorney document. It gives your attorney the power to also use your money to look after your children. Legally speaking, there's precedent which says a power of attorney is only supposed to be used to benefit the donor, meaning the person who wrote it. So that's weird because, well, why wouldn't the person who wrote it also want their children to be benefited? But when you consider that the person who wrote it might be 75 and their children are grown up, all of a sudden that changes the situation. So you could write into your power of attorney, if my children are less than the age of 18 and require support, which normally would have been provided by my assets, I allow my attorney, blah, blah, blah. And then you can use your will to set up what's called a young beneficiary trust. So the law in Manitoba is that anybody under the age of 18 cannot inherit, they cannot receive inheritance in their own hands. They must receive inheritance through a trustee until they turn at least 18. I don't know about you, if I inherited a bunch of money when I was 18, I don't know what would have happened. It scares the heck out of me, frankly. So many people use young beneficiary trust to actually increase the age at which their children might inherit. So a lot of people say 21 or 25. Somebody said 40 the other day, and I was taken aback, but that's what they wanted. You use the trust and you appoint somebody else to handle the money for the beneficiary, somebody you trust, somebody who's going to be in their life and cares about them, who's going to be around. And it's at their discretion that money gets used. Therefore, we're not worried about, an 18-year-old taking a whole bunch of money out and joining the circus or whatever, and wasting their money and being taken advantage of. Fine, join the circus, but you're not taking this $500,000 with you. You can also use a beneficiary trust to stage distributions out. So you could say, I trust you a bit at 18, but I don't trust you the whole way. So I'm giving you 25% at 18, another quarter at 25, and then the rest when you turn 28 or something like that. And then you can also specify the purpose for which their inheritance is used by their trustee. So you can say it's only for education, or you can say it's education and support, meaning, shelter, food, clothing, and life experience, travel, enjoyment, whatever that might be to you. A little bit on trusts. So we already just touched on one specific example for establishing a trust. That'd be for care of young people. Trusts can be established by you through your will, meaning they don't come into being until you pass away, but they can also be established by you while you're living. And that might be for specific reasons. You might establish a trust to care for somebody who has special needs or has addictions issues, and therefore wouldn't use money, or the money could actually harm them in some way. So somebody has special needs and they inherit a bunch of money from you. Their disability benefit, their other benefits provided by the government, in some cases can be shut off until all of their inheritance is gone, which is not usually the intention of the person providing that money. Sometimes it is, but why wouldn't you want them to have both? A trust can be used to protect against that situation. Trusts can be used when you like your kid a whole lot, but you don't necessarily like their spouse, and you want to protect the money or the assets or whatever, the inheritance that your kid might receive from a potential breakdown of marriage or common law relationship. And then trusts can be used for protection against creditors. So if, say, you run a business and your business has a lot of debt, and that's fine, but if something goes wrong in your business, somebody's coming after that money, you protect yourself by establishing a trust. It's perfectly legal. It's not hiding money. The trust just has to serve an actual purpose. It can't just be, playing keep away. And can be used for income splitting, which is for minimization of taxes. Okay, so those are all of the specifics I'm going to get into for a will, and I'll certainly be open for questions in just a little while. I'm going to touch on power of attorney. Way back at the start of this presentation, I mentioned that a power of attorney is used to appoint somebody else to manage your property during any potential period of incapacity, meaning you're not able to handle your own affairs or make your own decisions. Powers of attorney, there's a couple main types. So the first, the choice might be an immediate as opposed to a springing power of attorney. So you can write your power of attorney to be effective as soon as you signed it and as soon as it's notarized. That means that the person you've named could, if they had to, go about doing things for you and making your decisions at any point. It's not waiting for anything to happen. So that might make sense. Of course, you trust the person, you wouldn't name them if not, but you say, I'm of perfectly sound mind, but it's so horrible outside and I'm laid up and I can't, I don't want to go out on the streets today to pay that bill at the bank. So here, lucky power of attorney. I've said that it's immediately effective, so I'm sending you out as my deputy. Or we have a springing power of attorney. So that means you've signed it and executed it properly, but it's not effective. It's actually dormant until such and such a time as it becomes effective. And normally that time is specified as any time that you might be incapacitated, as deemed usually by a physician, at least one, sometimes two. Powers of attorney should be enduring. That's a specific paragraph, essentially, that goes into the document, and it says, this power of attorney is effective until I pass away, even if I lose capacity at some point. It's enduring through my incapacity. Sounds like that would go without saying. There's a piece of law which says if you don't include this clause, your power of attorney expires if you become incapacitated. Counterintuitive. I don't have a great explanation for it. It's just what I understand to be the law. You can use your power of attorney to include specific rules. You can say, I've made a bunch of gifts. I don't want anybody making gifts using my power of attorney. So you're not allowed to start doling out my money until I pass away. But you are allowed to continue with my charitable donations, which I normally make on an annual basis. You can say in your power of attorney, gosh, this is such a big job. Thank you so much to the person doing it. I am giving them compensation equal to a few $100 a month or something like that. A lot of people kind of approach the roles of executor or attorney as a privilege, or as if you're bestowing something upon them. You should consider it like a very, very weighty mantle or chore. And so, and I have permission to give this story, when I became a lawyer much younger, my folks sort of sat myself and my siblings down and said, Andrew isn't the oldest, but he's a lawyer now, so we hope it's okay with everybody. We're going to be putting Andrew in these roles. Nothing personal, no hard feelings. We figure he's going to know more about these in some time. They're sort of worried like that would be offensive or something like that. And I'm pretty sure my sisters high-fived behind my back because they knew they didn't have to have any part of this. Legally speaking, under a power of attorney, your attorney is required to provide an accounting, meaning to essentially open up the books and show account statements to other people who might have an interest in that person's finances. So just stemming off that example, someday if I'm ever acting for either of my parents as power of attorney, if they become incapacitated, I'm now the only person with authority to begin watching over those accounts. So where's the oversight? Legally speaking, the Power of Attorney Act states that I must once a year, at the very least, open up the books to my siblings and say, here it all is, here's money I've moved and why, et cetera, et cetera. I provide an accounting so that there's some kind of oversight. You can actually pick the person who you want that accounting to go to in your Power of Attorney document. What happens if you don't have one? So very common that folks come in and they wrote their will 30 years ago. And I say, do you have a power of attorney? And they say, yeah, we think so. Nothing's gone wrong since then, so we don't exactly know. But it turns out they decided not to do a power of attorney at the time that they wrote their will, or they thought they did because they knew they appointed an executor, but as I mentioned, those things are often confused. That can potentially be a big problem. And the purpose of this is not to scare you, it's simply to warn you. Even if you have a spouse or children with whom you get along perfectly well and you trust in whatever it is, if you don't have a power of attorney, those people can't necessarily just start making decisions for you. They need some kind of legal authority, and just being married to you isn't always legal authority. It might be if they're a joint account holder, but if they aren't, they're out of luck. And so what often happens is two spouses don't have a power of attorney for each other. One person becomes incapacitated, but most of their assets are joint, and it sort of just flies, like it's allowed to go. However, when the capable spouse, if they pass away first, there might be children sort of lined up, next at bat, but they have even less connection to the assets of the incapable parent. They're not joint. So even though they love their parent and they've, got a clean record or whatever, they can't just waltz into the bank and say, well, here's my birth certificate, that's my father or mother. They need a piece of legal authority to make decisions. And that's what power of attorney is. If you don't have a power of attorney, and if you become incapacitated, there's sort of two roads. The first is the Public Guardian and Trustee's Office. That's a branch of the government. It's essentially their purview to, look after the affairs of people who have nobody else to step in. So that would be people who don't have power of attorney. The second road is to apply to court to become a committee, spelled committee, said committee. That's a court application basically asking for the court's permission to act for somebody else. It's something the court takes extremely seriously for good reason. The court doesn't just like to give out power and control to other people all willy-nilly. You need two physicians to swear affidavits. The applicant has to swear an affidavit as well. Anybody else who might be at equal footing with the applicant, like siblings, must consent. You pay a lawyer to put all these things together. You pay a lawyer to appear in court. Then you have to account to the court every year and report, basically. It's a big headache. It's thousands as opposed to hundreds for a power of attorney. Again, not to scare you, just to warn you. Next, we have healthcare directives. So this is the third and sort of final basic estate planning document. So a healthcare directive, also known as a living will or a personal directive, or sometimes referred to as a DNR, do not resuscitate. The purpose of this is to appoint somebody to make your medical or healthcare decisions if you become incapable. Healthcare directives are governed by a separate rule or statute than powers of attorney. They're actually not really supposed to overlap. This is another misnomer or misunderstanding that people have, which is I have a power of attorney, that person can make my medical decisions. That's technically, legally speaking, not the case. Your medical decisions are supposed to be governed by your proxy named in a healthcare directive. You use that document to name the person or persons, and then you use that document to provide specific healthcare directions. For example, there's a certain subsect of Christianity, Jehovah's Witnesses, they do not accept blood transfusions. Healthcare directive is a perfect place to specify that. Other people say, I never want to be intubated. I understand everything to do with that. I don't want it. Put that in my healthcare directive so that if you get brought into the hospital and the paramedics wisely grab your emergency responder information kit, magnetized to your fridge, comes in with you, your physicians and nurses will know this is treatment you didn't want. That's how it works in a perfect world anyway. I believe that in reality or day to day, if you don't have a healthcare directive, many healthcare practitioners will rely on decisions made by your power of attorney, essentially on the basis that you've trusted that person enough to name them as your power of attorney of property and money and such. So presumably you trust them to make these decisions. I'm not saying the system is broken or that this is a problem. Simply trying to elucidate the legal difference between healthcare directive and power of attorney. Your lawyer can write one for you. You can also go to the provincial website or the WRHA website where there is a decision-making tool, and you can actually print out a very boilerplate power of attorney, healthcare directive, and execute it for free. There are no formal execution rules for healthcare directives like there are for a will or a power of attorney. Technically becomes legal. That's as far as I want to go in explaining healthcare directives to this crowd. I'm sort of cognizant that many of you on this call may be better able to explain healthcare directives to me than vice versa. So at the risk of putting my foot in my mouth, I'll move on. A brief note back to estates. So as of November of last year, the province eliminated probate fees. They used to be 0.7% of estate value. So if your estate's $1 million, $7 grand. I don't have a great explanation for why that was. I guess you could call it a death tax. 0.7% wasn't the end of the world, but either way, it's gone. Something to be aware of if you have property like a cottage in Ontario or in the US, there will be different treatments for your estate. And there are still taxes attached to certain of your assets separate from probate, such as what happens to your RSP if you pass away? What if only one spouse is on the title of a house? Or what if you want your house to go to a child? There will be land transfer tax from your estate, things like that. Just for the sake of time, you're welcome to ask me about this slide, but I will jump over it. I'd like to get to questions. This often doesn't affect folks. We'll just suffice it to say, speak to your lawyer if there are US persons involved in your estate. I'll jump over this as well, just mainly to mention more and more, we are holding wealth digitally. I'm not talking about Bitcoin necessarily. How about just a simple Quest trade account where you manage your own stocks online and there's no bank that to walk into, and your investment statements are only being sent by email. Well, if you pass away, who has access to your computer and your passwords? Not to mention things that are sentimental in value, such as, pictures of my nephew, things like that. your estate may want access to those things. It's good to plan ahead for digital assets. And it's only when you're giving presentations do you realize that some of your stock photographs could stand to be updated. But anyway, that's my information. If you prefer to query me directly rather than today, or you have to run, or whatever it is, I hope you'll feel free to contact me. I'm not going to plunk you with a bill for calling me or emailing me. And then otherwise, thank you everybody very much for attending. And Melissa, maybe now we can open it up for questions.
There was a few here. So the first one says, if we hand write our own will to have it notarized, will that be okay?
Great question. Maybe before I even start answering them, I'll have to let you know. I can't impart legal advice, meaning anything I tell you, it can't be relied upon. So boiling that down, don't sue me if what I tell you doesn't go exactly according to plan or causes issues, because I'm not being retained as a lawyer. Okay, I have to give a waiver like that. So there's a very specific way in which wills are supposed to be witnessed. In fact, there's a list of rules. A will must witnessed and written. So a will must be dated, and if you've written your own will, the date must appear somewhere close to your signature and hopefully on the first page as well. You should initial each page. Your signature should be at the end of the will. If you've written the will in your own hand, you don't need witnesses. If you're filling out a template or a will kit, you need 2 witnesses. And you actually need one of those witnesses to swear an affidavit. Both witnesses should initial the wills. I'm not sort of saying all these things assuming that you're scribbling all this down very quickly, but I'm saying this because most lawyers won't be comfortable to sort of bless a will that's brought to them because they will be concerned that a problem could arise having to do with your assets or your family or something that hasn't been considered and that they haven't had the opportunity to ask about before, notarizing or witnessing or blessing your will again. So I guess I would say that that's the response you should expect to receive. I don't know of too many lawyers who are keen to say, yep, bring in your will. I'll make sure it's properly executed and send you on your way. For one thing, it's because our business is predicated on writing these things. So to sort of hit the nail on the head. But because if it were me, I would have all these concerns and I would say, well, I don't want to attach my name to a document that in 20 years time, after I've long forgotten the situation, potentially blows up. So that's not a particularly direct answer to your question, but that's sort of what I can tell you about it.
Thank you. The next question is, could you set up a trust for our pet?
Yeah, great question. Yes, absolutely. So say in your will, you can establish a pet trust. You can set aside a certain amount of money and you can attach rules to that money and you can put somebody in charge, somebody presumably who hopefully likes animals and who may even be your pet caregiver. The reason you might do that is because you don't want to financially burden somebody who is going to look after your pet for you. You want to fund the care of your pet through your estate. And you can earmark a whole bunch of money and say, here's 30 grand. That's for vet, food, massages, whatever. And when the pet passes away, the balance of that money, if any, can be split between the caregiver as a gift to say thank you and then donate it to Humane Society or Darcy's Ark or whatever you like. Yeah, that's a great thing to do in your will.
Thank you. The next one is, can you have 2 power of attorneys for checks and balances, or do you assign one but identify a backup just in case?
Another excellent question. I guess yes to both of those. It'll always depend on your family dynamic. So, for instance, if you think that there are two people who don't get along so well, you might choose to separate them and say, well, they don't get along, but I know that this one's fair. And so they're going to be the first appointed person. But I'm going to include the check and balance, good use or a good phrase, to say that that person must account to the other one every 6 months or once a year. Or you might say, I just want them to share this job. They get along, my two children get along really well, but I don't want there to be secrets and I don't want there to be cause for distrust. So I'm naming them both. They'll have to go to the same meetings and sign the same forms and whatever else, which might be a bit of a hassle. But if it's important to you that they always have the same information at the exact same time, that might be a good thing to do. Melissa, I've gotten an anonymous question directly.
Sure.
So it says, if I am a single parent, but I have a child and I intend to leave everything to my only child in my will, and then a few years later I have a partner and we have a written prenup, can my partner still challenge my original will in the event of my death? So in general, when it comes to wills challenges, there are certain things you can do to protect against them. However, people can challenge wills, regardless how flippant or weak the reason might be. And there are consequences for challenging a will unnecessarily. But that said, crazy is as crazy does, and some people will simply challenge a will even when they don't have a legal leg to stand on. Sometimes it's really just a shakedown. So I'm going to make this big problem for your estate, and you can pay me to go away. I don't endorse that, but that happens. In this case, if there is a written prenup, you've, I think, taken the strongest step, the absolute strongest step that you can to protect the child from a future partner. Because let's say, in years gone by, the child and the partner have drifted apart or whatever it is. However, there is one law called the Dependents Relief Act, which cannot be contracted or agreed out of. So a prenuptial agreement is agreeing out of certain claims that one spouse may make against the other if there's a divorce or a death, but you cannot agree out of dependence relief. And so if one spouse was highly, highly dependent on another spouse who, let's say, passes away, they are entitled to claim relief against that spouse's estate. However, it's only to a certain extent. It's not to say I get half and your children has to give me that half. Your child has to give me that half. I hope that's an okay answer to your question. Sorry, Melissa, was there another?
The next one is a power of attorney different from proxy when it comes to healthcare decision-making?
Great question. And that was at 12:44, and that might have been almost exactly when I was differentiating. So hopefully I've answered that, but I'll allude to it a little bit or elaborate a bit. Yes, short answer is yes. Technically, legally, in a perfect world, they are separate things. A POA is supposed to be money and property. Healthcare proxy is supposed to be medicine, surgery, end of life decision making. There's a small overlap, like the middle of the Venn diagram would be concerning somebody's ongoing personal care. Because if they're going into, a fancy place like Brightwater Home or River Ridge or something like that, it's costly. And now you might necessarily, so the proxy has decided that that's the best place. And now the power of attorney enters and says, okay, we're budgeting for this now, and I'm making sure money is getting released, things like that. But otherwise, they're supposed to be separate.
Thank you. The next one is, do probate taxes prior to November 2020 still apply to a spouse transfer of the marital home that was joint owned?
If it's joint owned, then no. let's say it wasn't joint owned. There were a bunch of people, smart people, lawyers, following what the provincial government was saying about probate. Things got delayed. You might have heard of COVID. Disrupted a lot for the provincial government. So a bunch of lawyers stacked up a lot of very valuable estates on the corner of their desk and said, we're going to wait until this 0.7% probate fee goes away. And when it eventually does, we're going to file all of these probate applications. It does not matter that this person passed away before November 6, 2020. And simply by a little bit of patience, those lawyers were able to save thousands of bucks very easily for their estate client. Anyway, short answer to that question is probate taxes should never apply to jointly owned marital property. There's a question on top of that one, Melissa. It says, is it problematic to have two executors?
Oh, sorry, I missed that one. Yeah.
Not at all. It was a little one. No problem at all. It's only problematic if the dynamic between those two people is problematic. Or let's say one is really far away and it's super hard for them to communicate and take action for the estate. However, if both are on good footing with each other, hopefully close by, there's no reason that two people couldn't act. And frankly, sometimes it's a relief to share the burden with somebody in the decision making. So a very common example is there's two kids. They get along, they're both in town. Why wouldn't, you might just pick one, but if you could easily pick two as well.
Thank you. The next one is, speaking of cottages, is there any tax advantage to adding children to a title of a cabin before a parent passes so it becomes jointly owned? Great
question. Very common question. The same may go for adding child to parent's house. That's a piece of planning that most lawyers don't love. There's lots of problems associated, or there can be lots of problems associated. So it does not hide a capital gain to add a child later. Any gain to the cottage value during the time of ownership will still be there and will still be payable if the cottage was not the primary residence. So there's sort of no getting around that. You might save, well, you won't save probate fees anymore. You're adding the child now that you're giving them half the value of the cottage, so you'd only have to pay half of the land transfer tax. Okay, you save a little bit of money there. You open that child up to having an asset that would be included in division of assets upon breakdown of marriage. You open that child up to personal capital gains if they own another property. You open yourself up to problems dealing with or involving your child's creditors if they have them. You lose an amount of control over your asset because now your child has to agree with, say, mortgaging or selling or repairing, perhaps, unless you want to foot the bill. So for a whole host of reasons, we normally don't recommend it, especially now that the probate fee is gone. There are very, very narrow circumstances where it might make sense. I think, and I'll argue with folks, and there's been one time where I got argued down, and I was convinced that yes, that did make sense. It was a single, one child who was single, who didn't own their own property. So it made perfect sense. But unless it's that narrow circumstance, I usually say forget it. Oh, and the second thing is if you have, or the other one came to me. If you have multiple children, you're giving that child this asset. It's not part of your estate any longer. It's not governed by your will. Legally speaking, the child who is remaining on title after you pass away has no obligation to share that asset with their siblings. They very well might get along just fine right now, but if there's a falling out before you pass away and you haven't changed the title again, that could just be their cottage. So sometimes those are major considerations. Great question. Thank you.
Will you have a session on adult children with disabilities on social allowance? I am SDM for property and medical, personal/medical needs.
Sure. I'd be happy to. I don't know that I'd be the best person, but I know the best person. A colleague of mine, whose name is Krista, I believe knows this stuff up and down. And so, Melissa, if I can impose on you, if you ever have need for another presentation, I would be more than happy to connect Krista to you to put on something like that, because this is a very common issue in terms of estate planning and just navigating this, frankly, at times insane system that operates in our province.
Great, thank you. The next one. What is the general cost for creating a basic will or POA?
Great question as well, and perfectly happy to answer it as upfront as I possibly can. So at my office anyway, for basic will, so like spouse then children, we typically charge $850 before taxes, and that would get you 2 wills. So say, one for your spouse and one for you. So that's $850 total as opposed to $850 each. Powers of attorney, same deal. Normally we provide 2 for about $250. I can tell you up front, I don't think that we're the cheapest shop in town. In going through that process for you, essentially what we would be doing is digging in and ensuring that a basic will suit your needs and will not cause problems later. Because oftentimes, and meaning no offense by this, about 9 times out of 10, somebody will say it's a basic will. People who call me or whatever it is, I just need something straightforward. And that's very well their intentions. When I sit down with them and learn about their family or their assets, it's extremely common that I spot an issue and say, we can go forward with the basic will. I have no problem with that. It means nothing to me. I'm not personally affected. However, it's my job to tell you what this issue is and what could become of it if it's not treated through your will or in some other fashion. And now all of a sudden the will is no longer basic because we might need to employ a trust or specific powers under a power of attorney, something more comprehensive. So anyway, in a roundabout way, if you do need the general will through my office, $850 before taxes, you'll find cheaper. And that's just fine. And that's no hard feelings whatsoever. The only thing that I would be upset for you about is if you go to another will and go to somebody and they don't ask you much about your family dynamic or your assets. They just take the names that you want put into spaces in a template. That might be fine. It might also cause a lot of issues. So that's the only kind of pitch I'll give for my own services.
Thank you. What happens if you write a will in one province and then relocate to another province?
Great question. There's sort of an interjurisdictional agreement across most provinces, I think, except Quebec. They do their own things out there. That's fine. So in Manitoba, for instance, it's part of the Wills Act. It says any will or testamentary document executed properly according to the rules in the jurisdiction it came from. So you went to a Saskatchewan lawyer, you moved to Winnipeg. Perfectly fine will. I guess you might like to have it looked at to make sure it was executed properly over there. But if you're pretty sure about it, then yeah, it's perfectly valid.
Thank you. Next question is, just in case my copy goes missing, how long does it stay with the lawyer?
There's only ever one original. It very much matters who has it and how it's kept safe. Some lawyers will ask you if you want them to hang on to it for you. Other lawyers will say, I've got 10,000 wills in my vault, and this is becoming a huge liability. I do not want this anymore, and I'm not offering to you. You're taking the original. You have to keep it somewhere safe. If an original is lost or destroyed or whatever it is, it might be a really easy fix. You might call that same lawyer and say, I have a copy, but it's not the original. Let's meet, let's just re-sign the thing to make sure I have the ink copy. And the lawyer might say, I have no idea who you are. You know, we should meet, talk about your assets. And you say, no. Let's just meet. I'll pay you $100 or whatever it is. We'll meet and sign. You can do it that way. If, as will more commonly happen, or sometimes happen, it's not discovered that the will is gone until somebody passes away. Now you can't re-sign that will. Your estate can apply to the court to have a copy of a will showing a signature, but it's not the ink copy. I know it sounds ridiculous. You can have that copy, it's called proven. So the court needs to hear evidence as to why this copy, you know, why we shouldn't just consider the will gone on purpose. So if the evidence is, I have the copy, the original was destroyed in a fire, the fire is what caused this person to pass away, it's very clear to me that this person still intended to have this be their lasting will, the court will say, yep, check, no problem. But in a situation where somebody handwrites 300 wills over the course of 3 years, which is a case I dealt with, which will is the will? If there's copies, if there's originals, how do we know where along the way this person meant to you know, put the pin in their original will? Now you have this huge issue, and you have to bring all this evidence before the court to just get the court's advice and direction. That's probably more that's more of an answer than you really need. Keep your copy safe, safety deposit box, tell somebody where it is. If it's gone, act quickly and re-execute.
Thank you. Under what circumstance a probate is unnecessary in order for the executor to act?
It will depend on the asset, I suppose. So I'll sort of read into this question. When do I need probate to handle an asset? So thinking back earlier in my presentation to joint assets or beneficiary designations, those are assets which do not travel into your estate and therefore do not require probate. More about probate, I guess. Probate is the legal process through which a will is blessed by court, and with that blessing, it's a probate order that issues. An executor may now take the order to the bank and remove funds for distribution or control, or take that order to land titles and put the house into the estate's name. Solely held assets, like a house or a bank account without anybody else's name on them, cannot be handled without a probate order for the most part. Banks have their own policies and protocols, and the land titles office has its own policies and protocols. Basically, they're not comfortable giving out this asset to somebody without the court's approval of the will in the form of the probate order. You can see why. If the land titles office changes the title of a house worth $1 million to somebody who says, here's the will, I'm the guy written in the will. But it comes to light that there was a later will that revoked the last one, and this guy was taken out of it because this guy's a shyster, and land titles put the house over to that person. Now land titles is in extremely hot water. So there has to be some kind of legal oversight, which is the probate process before anything gets handled. But probate, to answer your question directly, is unnecessary when it comes to handling things like funeral. Usually just a will is going to suffice. or joint assets or beneficiary designated assets? Good question.
Can a POA decide for the health of a client if there is no identified proxy?
I think yes. I was curious about this. I was self-conscious about to be presenting to a bunch of people who very well might deal on the ground with healthcare directives, whereas all I do is write them and send them on their way. So I spoke to a physician immediately before this and said, how the heck do these things work? To answer your question, it seems like yes, a power of attorney will be or can be looked to make healthcare decisions if there's no identified proxy. Legally, that's wrong. Again, I don't know that the system is broken. I don't know that this is a problem. My concern would be someday there's a healthcare proxy, that's person A, and then there's a power of attorney and that's person B. And the healthcare directive doesn't make it into the hospital the first day. And somebody looks to the power of attorney and says, what should we do? And they say, well, do this. And then the healthcare directive makes it in. And now we've got somebody who's extremely opposed to what just happened. And now we have a big case. I don't want that situation to happen, but I do want to know what the court will say about it. And maybe this will sort of cause more buy-in for the delineation of how these things are supposed to operate. But for right now, that's sort of the best I can tell you. And I'm not saying the system is broken. Try not to trip all over myself here.
Thank you. There's one follow-up question regarding the relocation. So how about if I move to a different country and the country uses less common law like Canada?
Uses common law.
Sorry.
This is great. I feel like I'm giving a verbal exam. If you're moving to a common law jurisdiction, UK, New Zealand, South Africa, Australia. Anyway, I think I would err on the side of writing a new will anyway. It's very possible that your Canadian will is legal in the UK or Australia or New Zealand, e.g. Hope you're moving to Fiji. However, the cost and the time and the difficulty it might take to have your new will confirmed as legal might be way, way more effort and trouble than just doing a new will again. So that would be my answer to you. I would say skirt the question altogether, don't risk it, and just, swallow the pill of having to sit down with a lawyer again and do it again.
Well, thank you. That's it. Looks like that's it for the questions. So I want to thank you, Andrew. Thanks so much for spending time with us, and your session was very informative. And thanks to everybody who was here today for the session. And if you have any feedback, feel free to email the Family Center at familycenter@umanitoba.ca. Thanks,
everybody. Thank you so much. I appreciate all your questions. Thank you very much, Melissa.
Thank you.